Hi, I'm Barb Culver, and I'm the president of Resonate Incorporated in Cincinnati, Ohio. Thanks for joining me today. I hope that you will find this topic to be of especial interest because it's very current. As you know, we pride ourselves in providing you with what we believe is the latest important information on a wide variety of topics that has to do with financial and legacy planning. And today we're going to talk about what used to be called estate planning, and today is being renamed lifetime transfer planning and the digital estate. So let's start with this concept of lifetime transfer planning. Influenced in part by the fact that many of us are living longer than the estate tax laws which are currently on the books ever anticipated. An increasing number of people believe that they receive the greatest benefit from their estate assets when they transfer or share some of their property before their death, while they can still enjoy it, guide, and affect the outcome of those transfers or gifts. The estate tax planning terminology for this technique is called gifting. And there are two different ways that Americans are allowed to gift today. The first one is called the annual gift exclusion. And what the annual gift exclusion does is it allows for anyone to transfer up to $14,000 per calendar year to as many people as they would choose or can afford to make that transfer. What that means is you can give $14,000 in cash or appreciated securities or appreciated assets or some combination of the above with no tax consequence to you, nor is there any tax consequence to the recipient. You can give $14,000 per year per person. There is no limit to the number of $14,000 gifts you can make in a given calendar year. That's why it's called the annual gift exclusion. And if you are married, both husband and wife or same-sex partners who are legally married can gift up to $14,000 to the same person. So, for example, if you would like to make a gift of $28,000 to your friend, son, daughter, grandchildren, you can do that under the annual gift exclusion by combining the $14,000 allowance that each person has every year to give away. Now, before you might act on this, there are several important things for you to note that we would encourage we'd have a conversation with you about. For example, there are real reasons why you might not want to gift the entire allowable $14,000 per person. In addition to that, there are special medical and educational exceptions to this rule which allow you to gift even more than the $14,000 per person per year. So while I'm sharing this concept with you today, I would highly encourage you to have a follow-up conversation with us about it so that we are sure you are maximizing the potential of this gifting for you and your loved ones. Why do people even think about gifting away some of their estate prior to their death? Why are they interested in this concept of gifting? Well, in addition to expressing love and affection for the recipients, gifts can also send the following messages. I or we trust you. I or we have confidence in you and your ability to receive and handle this money. I or we want to help to create more opportunities for you now, rather than having you wait until we pass on. I or we are grateful. We have been so blessed, and we want to share some of our abundance with you now. In addition to these intangible messages that are sent, there are also some tangible reasons or technical reasons that people gift. For example, the gifted assets are removed from the estate of the grantor. That means that there could be a reduction in either probate, expenses, and or possibly estate taxes. Plus, by gifting, you create an income tax savings because you shift any taxes associated with those assets that you've given away from one family member who may be in a higher income tax bracket to another family member who may be in a lower income tax bracket. So there are intangible or qualitative reasons for gifting, as well as tangible, technical, quantitative reasons for using the annual gift exclusion. Now, in addition to the annual gift exclusion, our federal law also includes the opportunity to make cumulative gifts over our lifetime that would be in excess of the $14,000 per year. And by the way, that $14,000 per year limit is raised from time to time to allow for the inflationary increases that we've experienced within our own U.S. economy. Lifetime cumulative gifting. In 2015, that number is now $5.43 million per person. So that means in addition to the $14,000 per year per person, you can also gift a total of $5.43 million cumulatively throughout your lifetime without incurring any estate or transfer taxes. Now, some of you I know have already maxed out your lifetime exclusion based on the 2014 tax laws. And we want you to know that that limit did increase in 2015, which opens the opportunity for you to create more lifetime gifts again. Please contact us if you'd like to have the information on what the new 2015 lifetime cumulative gifting law is. So that concludes the portion of this presentation on both annual and lifetime gifting. And now I want to talk with you about what is called digital estate planning. In my experience, in talking with clients, very few people have actually considered the importance of adding digital estate planning to the former traditional estate planning that you may have already completed. In the past, when an estate needed to be settled, basically what happened is that the executor or executrix of the estate, along with an attorney, sifted through lots of paper, financial statements, personal, business, as well as valuing and dealing with tangible assets and real property. Little to no time or thought was spent on the intangible assets of one's estate. That is no longer true. Digital estate planning consists entirely of digital property, which is defined as any information about you or created by you that exists in a digital form, either online or on any electronic storage device. This includes information that's necessary to access the digital asset. All of your digital property comprises what is known as your digital estate. So let's break that down and give you some examples of what I mean. Today, digital property is broken down into three main categories for digital estate planning. The categories are personal digital property, personal digital property with monetary value, and digital business property. Personal digital property. Let's start there. This includes such things as your computers, smartphones, digital music players, e-readers, digital cameras, and any other digital devices that you may own. It also includes any information or data that is stored electronically, whether stored online, in the cloud, or on a physical device. In addition, personal digital property includes any online accounts such as emails, social media accounts, shopping accounts, photo and video sharing accounts, video gaming accounts, online storage accounts, websites, and blogs. It includes domain names and intellectual property, such as copyrighted materials or trademarks. If we just stop there for a moment, and I share with you our recent experiences of utter frustration, stress, and despair of the people who are expected to help settle the estate of a loved one, who have no idea at all where all those devices are, which accounts existed in total, nor oftentimes are they left a list of passwords. And you know as well as I do how often we are required to change our passwords. The loved ones who need to get into your accounts to be able to complete your estate planning are absolutely stuck. They feel bad, they are frustrated, they are stressed because they don't have the information that they need, and it is very time-consuming and sometimes seemingly impossible to access that data. So just thinking about your personal digital estate and making sure that you have a complete list of all those things I've just mentioned, including your password, given to the person who has your power of attorney for financial affairs, the person who has the opportunity to serve as your executor or executrix of the estate, is absolutely crucial. Now let's move on to the personal digital property with monetary value. Basically, we're going to include the same types of devices that we've already mentioned: computers, smartphones, digital music players, digital cameras, any other digital devices of monetary value which are used to create income. This is your personal digital property with monetary value estate. Once again, if you have a website or a blog that generates income for you, if you post art, photos, music, if there are e-books, intellectual property, or any other type of digital property that generates revenue for you, this is all a part of your personal digital property with monetary value. Accounts that you use to manage money, to hold money or credits like PayPal, bank accounts, loyalty rewards programs, any accounts with credit balances in your favor, domain names. Once again, all of this needs to be recorded and shared with those people that you are counting on to be able to serve in your behalf if you are incapable at some point during your lifetime, and also those people that you are counting on to help settle your estate when you're gone. Digital business property includes any digital property owned by a business organization, any online accounts registered to a business, any assets of an online store that you manage, such as an online store or an eBay account, an Amazon account through which you might sell things, any mailing lists, newspaper subscription lists, or email lists that have your company's clients, any client information, including client or customer history. All of those are representations of what would be included in a digital business property estate. So the purpose of this program today is simply to get you thinking. And based on my experience, this is such an untapped area that we are finding it is essential to remind all of our clients about it as we meet for your annual, semi-annual, or quarterly updates. It's also so important that we wanted to get this out in this video presentation to reach you in case your regular update comes later in the calendar year. One of the things that I think we can do for our clients in terms of leaving them the greatest legacy gift of all is to make sure that we do not leave them any messes to clean up. Those messes can be emotional, psychological, financial, legal, spiritual. We can help you with the financial, and with our virtual team of attorneys and CPAs, we can also help you with the legal and the tax. Please make sure that your final gift, that a part of that legacy that you leave your loved ones, is an estate that is organized, efficient, and clearly communicated ahead of time to make their job, which is to have time to grieve your loss, possible, as opposed to having to work their way through documents, files, and accounts about which they have no knowledge, yet they've been given the responsibility to be able to carry on in your behalf. Thank you again for listening today. I hope that this information is not just of interest and of value, but I also sincerely hope that my message today is motivational so that you will act on it. If you'd like us to help, if you'd like us to facilitate the process, just let us know. Contact us, call us at area 513-605-2500, area 513-605-2500, or contact us through the web at www.resonatecompanies.com. Thank you.